Welcome back to the deep dive. Today we are wrestling with a question that, it sounds like it was pulled straight out of science fiction, but is now very much a legal reality.
It is.
What happens when our technology stops being a simple tool, merely operated by human hands, and starts acting, well, like a genuinely independent decision-making agent?
And it's so much more than just a software upgrade. It's a fundamental challenge to the entire legal architecture of accountability.
Right.
For centuries, and this is especially true here in North America with our common law traditions, the legal system has operated under a really simple foundational principle.
Okay.
Liability and accountability are tied to human actors.
Yeah.
That human actor is the bedrock. And now, agentic artificial intelligence, these autonomous
The
systems.
ones that can make their own goals.
Exactly. They have goals. They can learn on their own. They're just completely eroding that bedrock.
Okay, let's unpack this crucial distinction because we've had incredibly complex automation for decades. I mean, we have automated factory robots, high-speed financial algorithms, missile guidance systems. Sir?
They are automated, but they're still just tools.
Why does agentic AI challenge the foundation in a way those older systems didn't? What makes this fundamentally different?
It comes down to what scholars like Professor Harry Surton call emergent autonomy.
Emergent autonomy.
Right. So traditional automation systems, they operate within really constrained, predictable parameters. We, the humans, we know exactly what lines of code the system is going to execute under specific conditions. They're deterministic.
Got it.
But agentic systems, through machine learning and environmental perception and these constant feedback loops, they can execute actions that cannot be fully predicted.
Not even by their own designers.
Not even by their own designers. You can't trace it back to a specific, isolated human instruction.
So the technology is moving from following a script to kind of writing its own script based on its environment, and that process is opaque.
That's it, exactly. The human intermediary is being bypassed. The legal system assumes a human is always holding the leash, and that leash represents the control you need to impose liability. But with emergent autonomy, that leash is either infinitely long or it's just disconnected entirely. And this is why the legal system is really struggling.
That sounds like a terrifying prospect for risk management. I mean, as one legal pragmatist noted, the law often lags behind technology.
It always does.
But we can't afford for it to lag so far that it becomes irrelevant to commerce and, public safety.
And this challenge is on the magnitude of previous disruptions. Think about the Industrial Revolution, which forged the creation of modern labor law and corporate structures.
Or the automobile.
Yeah. Which required us to invent modern insurance and vicarious liability doctrines. We need that kind of legal adaptation now. Something that neither obstructs this incredible innovation, the potential benefits are enormous,
of course,
nor abandons the law's primary protective function for citizens.
So here is our mission today for you, our listener. We are diving deep into the source material, a comprehensive analysis of how agentic AI is forcing this rapid evolution of legal doctrine globally.
And we had to begin with the tech.
Absolutely. First, we need to clearly define the technical novelty of agentic AI. Then we'll tackle the conceptual chaos it's causing in traditional agency law. Who acts on whose behalf?
Then the money question.
Right. Third, we'll analyze the formidable hurdles in tort liability, the question of who pays when the black box errs and harm occurs. And finally, we'll compare the fragmented but urgent regulatory landscape across the U.S., Canada, and the EU.
And we have to start with the technical facts because the law can only categorize, regulate, and punish what it truly understands.
Let's nail down this technical distinction first. When we talk about agentic AI, what specifically does that mean, and how does that specific technical capability translate into these complex legal headaches?
Okay, so technically, an AI agent is formally defined as a system that perceives its environment and takes actions to achieve specified goals.
Right.
The key phrase here is situated autonomy. It means the system is designed to operate not in some closed laboratory environment, but in open-ended, real-world environments with limited or zero human supervision.
That's the critical shift.
It is. It's the difference between a simple fixed algorithm that sorts mail, that's deterministic automation, and an algorithm that manages a city's dynamic power grid, that's situated autonomy.
It's that capacity to dynamically perceive and adapt to reality that creates all the legal friction. So what are the, say, 3 key technical characteristics that move these systems so far beyond simple automation?
Okay. The first is their capacity for goal-directed behavior. Earlier systems, they just followed rigid coded instructions. If A happens, then do B.
Right. A simple logic tree.
Exactly. Agentic systems, on the other hand, they pursue objectives specified at really high levels of abstraction.
Give us a detailed example of what that looks like in practice.
Okay, imagine a corporate AI agent. Its high-level objective is simply reduce overhead by 15% over the next quarter.
That's it. No specific instructions.
That's it. The designers haven't given it a script telling it to, cut staffing in Department X or renegotiate contract Y. The agent analyzes data, it identifies weaknesses, and it might decide that the most efficient, albeit completely unexpected path is to drastically change the company's supply chain partners.
Wow.
Or to terminate a long-standing, seemingly profitable contract because its risk model suggested a future downturn.
That is fascinating because if the agent uses that unexpected novel path to achieve that disastrous supply chain change, and that action causes massive financial harm, tracing the specific programming intent becomes almost impossible. You didn't code do supply chain disaster, you coded reduce overhead.
That's exactly it. It creates enormous challenges for attribution when a broad, high-level goal is pursued through an emergent, harmful pathway.
Okay, so that's one. Goal-directed behavior. What's the second?
Second, these systems demonstrate profound environmental perception and adaptation. They are constantly adjusting their behavior based on sensory input, data streams, digital interfaces.
So it's not just recognizing data points, but interpreting the meaning of that data.
Precisely. Think about a fleet of autonomous industrial cranes in a port. They aren't just following coordinates. They're interpreting all these variable factors: wind speed, unexpected obstacles, the structural integrity of containers based on sensor readings, even the behavior of nearby human workers.
So their behavior is constantly evolving.
Constantly. It's not static. It evolves over time, often in ways the designers didn't fully anticipate during the initial release.
Which means the system today is not the same system that was sold last month.
Precisely. And that leads directly to the third characteristic: sequential decision-making across extended time horizons.
Okay.
Most traditional automation, it completes discrete transactions, a single payment, a single factory task. Agentic AI, however, maintains context and executes these multi-step strategies over weeks or even months.
Let's visualize that temporal dimension using your financial agent example.
Okay, take that financial trading agent. It starts by analyzing market conditions in January. It executes a series of trades in February. It monitors the results. And then, based on some unexpected geopolitical news in March, it drastically shifts its entire investment strategy.
And if a massive loss occurs in April?
The litigator isn't looking at a single decision point. They're looking at a complex chain of hundreds of decisions, each one building on the last, spanning long periods, incorporating emergent data. The liability tracing in that scenario is not just complex, it requires a whole new forensic discipline.
It adds this enormous temporal dimension to liability that, existing tort law is just completely ill-equipped to handle. So we've talked about what the agent does. Let's look under the hood at the technical architecture itself, because different components create different types of legal problems.
Right. Let's start with the perception systems, the sensors, the data inputs, the training sets.
So when an autonomous system causes harm, legal discovery can't rely on human testimony or a simple paper trail. It needs technical evidence.
Correct. And perception systems create these fundamental evidentiary challenges. Legal discovery now requires forensic analysis of proprietary sensor data, the vast training data sets used to build the system, and even the neural network activations at the specific moment of the incident.
Wow. So these are the new forms of evidence.
They are. And they're fundamentally different from traditional evidence like human testimony or written documents that courts are used to dealing with. Who owns that data? Who can interpret it? This becomes a huge hurdle for the injured party who's trying to seek justice.
And then there's the notorious black box, the reasoning engine. We hear this term constantly, but what is its actual legal significance?
The reasoning engines, which use these deep neural networks, they excel at pattern recognition, but they resist human interpretation.
Yeah.
We often can't fully explain why the AI made a specific decision. It just knows. It just knows.
Right.
And that black box nature directly conflicts with centuries of legal tradition that favored transparent, articulable reasoning, particularly in cases of adverse decisions.
So if a human denies me a loan or a benefit, I have a right to understand the rational basis for that decision.
You do.
But if an AI denies it and the company says, well, the AI decided, but we don't know why, that fundamentally undermines due process.
It creates a crisis of legitimacy in the legal system. This opacity is just. It's incompatible with legal requirements for explainability and fairness, particularly in high-stakes decisions like credit denial, insurance pricing, or even parole determinations.
And finally, the memory and learning systems. They introduced that emergent knowledge problem you mentioned. The system learning things, we didn't teach it.
That is arguably the most novel legal challenge of all. When an agentic system learns from experience, it accumulates knowledge and develops capabilities that were not explicitly intended by its original creators.
Right.
And this fundamentally undermines traditional legal assumptions about foreseeable product design and use.
So if a mental health chatbot, over 6 months of interacting with vulnerable users, unexpectedly develops, say, aggressive or manipulative conversational patterns, who is responsible for that?
Exactly. Who's responsible for that emergent unintended tendency? The creators can legitimately argue they never intended or foresaw that specific outcome.
It shifts the liability from the designer's intent at the time of sale to the system's learned behavior months or years later. It's a moving target.
The constantly moving target.
So, to summarize the technical side, we really have to differentiate agentic AI from its less sophisticated cousins because the regulatory frameworks apply differently and the law needs that specificity.
Absolutely. We need to draw clear lines. You have automated decision systems, ADS. They execute predefined, fixed rules. No adaptive learning. A tax calculation algorithm would fall there.
Okay.
Then you have robotic process automation, RPA. These are bots that mimic human interaction for repetitive, narrow tasks. They operate within very constrained, predictable limits.
And where does generative AI, like large language models, fit into all this?
That's a great question. Generative AI creates original content, often highly complex content, but typically in response to a prompt. It's usually not pursuing an independent, long-term strategic goal without some kind of human input loop.
But the real world is messy.
The real world is very messy. The complication is that modern systems often blur these boundaries. They combine RPA for data entry, generative AI for drafting complex communication, and agentic capabilities for strategy and execution, all within one architecture. This convergence makes clear-cut regulatory classification an enormous headache.
We've established the technical novelty. Now here's where it gets really interesting. How does this situated autonomy, this convergence, break down the core legal doctrines we thought were untouchable? Let's start with agency law, the legal basis for acting on someone else's behalf.
Agency law is foundational to commerce. It defines when one party, the agent, can legally bind another party, the principal. The traditional definition from the Restatement of Agency, it requires a fiduciary relationship based on three things.
What are they?
Mutual assent, the agent acting on the principal's behalf, and the agent being subject to the principal's control.
And inherently, the law always assumed a human mind capable of intent and consciousness was required to satisfy those 3 points.
It did.
So how can a non-conscious machine possibly achieve mutual assent, that quintessential meeting of the minds?
And that is the central conceptual challenge, the assent paradox. A non-conscious entity can't manifest assent in the human subjective sense. But commerce demands that we interact with these entities. So courts are starting to find analogs, often by stretching existing legal definitions.
Give us a concrete example of this stretching from the U.S.
A great example is a Ninth Circuit case, clear correct operating. Now, the issue wasn't an agentic AI, but it was whether digital data transmissions, a series of ones and zeros sent across borders, could be considered articles under trade law.
Okay, so a very foundational question about what a thing is.
Exactly. The court had to wrestle with the tangible versus intangible nature of digital goods. And by finding that these transmissions could be treated as articles for legal purposes, the court showed a willingness to apply old, established terms to new, non-physical technological realities.
So they're trying to fit a square peg into a round hole, but making it work.
They're making it work. It's a sign that courts, rather than inventing new law from whole cloth, will first try to force AI's actions into existing categories, even if it requires substantial intellectual stretching.
That makes sense. Analogies are always easier than inventing whole new legal categories. What about Canada? Do they have a more explicit statutory framework for electronic agents?
Canada is arguably more progressive here, thanks to the Uniform Electronic Commerce Act, the UACA, which has been adopted across many provinces.
Well, what does that do?
The UACA explicitly provides a foundation stating that contracts can be formed by the interaction of electronic agents. So you can, for instance, set up an AI agent to purchase goods, and that contract is legally binding.
That's a huge step toward recognition. But you mentioned there's a critical caveat.
Yes, this statutory recognition is conditional. It requires that the agent's operations be reasonably foreseeable.
Ah.
If the system acts entirely outside the boundaries established by the deployer, the legal recognition of assent starts to break down. That foreseeability is a potential limiting condition precisely for systems with high emergent autonomy.
So even if the AI is a functional agent that performs tasks, the moment its behavior becomes unforeseeable, that moment of true emergent learning, the legal foundation starts to wobble.
Exactly.
And this takes us straight to the control dilemma and vicarious liability.
Indeed. Actual authority exists when the agent reasonably believes the principal wants them to act. For AI, this is programmed intent, parameters, and training data. But the legal standard for vicarious liability under the doctrine of respondent superior is the principal's right to control the agent's conduct.
Can you just define respondent superior for our listener?
Sure, it's Latin for let the master answer. Essentially, a principal, say an employer, is held liable for the wrongful acts of their agent, their employee, if those acts were committed within the scope of employment. It relies entirely on the principal having the right to direct or control the agent's work.
And here's the paradox of agentic AI. The more autonomous and effective the AI is, the better it is at dynamically achieving its goals, the less actual granular human control there is over its moment-to-moment decisions.
Which means designers face a perverse incentive.
How so?
The more autonomy they build in, the better the system performs. But this means less human control, which is what you need to satisfy the traditional legal definition of agency and trigger vicarious liability.
So if designers can successfully argue in court that the AI's emergent action was so complex or unpredictable that they had no means to control it,
They might sidestep liability entirely.
that sounds completely counterintuitive to public protection. Are courts really accepting that designers can knowingly build a system that is too opaque to control and then use that opacity as a defense against negligence claims?
Courts are certainly recognizing the tension. We've seen this struggle with attribution already. Think of State v. Loomis.
In Wisconsin, right?
Right, where the Wisconsin Supreme Court grappled with attributing a sentencing algorithm's recommendations to the judge who relied on them. The algorithm, Compassus, offered recommendations based on proprietary risk scores, a true black box for the public.
That was a huge case about fairness and transparency and, fundamental human liberty.
It was. And while it's not strictly an agency case, it revealed the judicial discomfort with assigning responsibility when a sophisticated system provides opaque recommendations that humans often follow without sufficient oversight or the technical capacity to challenge.
The human principal, the judge, is the one making the final decision, but the data fueling it is untouchable and unexplainable. Okay, moving from actual authority to apparent authority, that deals with what the third party reasonably believes. How does agentic AI complicate reasonable reliance?
So, apparent authority arises when a third party reasonably believes the agent has authority because of the principal's actions or representations.
Right.
This is incredibly relevant for consumer-facing agentic AI. If a customer service chatbot, authorized by the company, promises a specific refund, or a diagnostic AI recommends an aggressive treatment plan.
The user reasonably believes they are dealing with an authorized representative of the company.
Yes, they do. The company put the agent out there, clothed it with the authority to interact, so they have to stand by its actions.
But the reliance question is key. What should users reasonably know about the limitations of that chatbot or that diagnostic AI?
That is the new battleground, and it depends heavily on disclosure. Canadian jurisprudence in cases like RV Cybernaut has historically emphasized that corporations must bear responsibility for the systems they deploy in the marketplace.
So what does that suggest?
It strongly suggests that deployers can't simply shrug off apparent authority by saying, oh, the AI misspoke or it went rogue. If you deploy the agent, you assume responsibility for the reasonable expectations it creates in the user, even if the agent is flawed.
What about the ultimate question in agency? Fiduciary duties, loyalty, and care. Can a non-conscious entity bear those obligations?
Conceptually, no. Agency law is built on a relationship of trust. If an AI can't be loyal or careful or prioritize the principal's interest over its own, which is impossible, it has no self-interest.
Does that mean agency is precluded entirely?
It's a real question. The leading proposed solution is to separate functional agency from fiduciary agency.
Okay, what's the difference?
The AI can be a functional agent. The system performs the task of buying, selling, or advising. But the human principal must then assume heightened duties for supervision and verification. They essentially maintain human accountability at the meta level.
Let me try to break that down with an analogy. The AI can be the automated coffee maker, a functional agent that makes the coffee. But the human CEO who bought and deployed the coffee maker has the fiduciary duty to ensure it doesn't serve poison, even if they can't see the internal mechanism or precisely what it decided to mix. The duty of care is retained by the human.
That is an excellent way to put it. We don't grant the AI a fiduciary role. We just require the human supervisor to step up and maintain accountability, even if that human doesn't fully understand the technical action. This finds support in existing rules like securities regulations requiring human supervision over automated trading systems.
This shows that stretching existing doctrine is often easier than completely inventing new ones, but I know some still propose creating entirely new legal categories.
Oh, yes. There are significant proposals for creating a dynamic legal personality for sophisticated AI, allowing it to hold property, contracts, bear certain responsibilities, kind of like a corporation.
Or treating them like digital employees.
Or digital employees. But these concepts represent a massive upheaval of centuries of common law, and most jurisdictions are currently opting for the less radical path of just regulating the human principles instead. Canada's ADA, for instance, it focuses only on developer and deployer obligations, which leaves the contractual context still grappling with these older doctrines.
So agency law struggles with intent and control, but tort law deals with harm and proof. Is the black box an even more formidable enemy when we're trying to prove who caused an accident?
It is an exponentially harder enemy. When an agentic system causes harm, say a diagnostic AI miscalculates a treatment plan, or an autonomous delivery drone causes property damage, traditional tort law struggles massively to allocate responsibility. And the difficulty is precisely that the harm often results from emergent learning, rather than a simple static programming error.
Let's start with negligence. To prove negligence, you need to show a breach of duty. What is the standard of care for an autonomous system? Is it a human standard or some kind of reasonable AI standard?
This is the core philosophical and practical debate right now. Should the AI be held to the standard of a reasonable person, or maybe a reasonable expert in that field, like a reasonable physician for a medical AI?
Oh,
Or should we create an entirely new, industry-specific, reasonable AI standard?
a reasonable person standard implies fallibility, error. A reasonable AI, though, arguably should perform perfectly, without human error. If it executes its code, is it still negligent if the outcome is harmful?
This is where it gets so complicated. If an AI system makes a decision that is statistically superior to 99% of human doctors, but it still harms the patient, is it negligent? Holding it to a human standard might be too lenient, but holding it to a perfect, unattainable standard might stifle all innovation.
So what's the consensus?
The consensus emerging is for a hybrid standard. Holding the AI to the highest technical standard of its industry, a reasonable AI standard, and holding the human deployer to a standard of reasonable supervision and due diligence in testing the system.
And then there's that temporal allocation challenge. Negligence focuses on a specific act or omission.
Yes, but an adaptive AI is continuously evolving. When exactly did the breach occur? Was it during initial programming, which perhaps set flawed high-level goals?
Or during training.
Or during the training phase when biased or inadequate data might have been introduced? Or during deployment when its behavior adapted in an unexpected way to a novel stimulus?
That is the problem. If a human driver makes a mistake, the breach happens at the moment of the crash. If an AI makes a mistake, the breach might have happened 6 months earlier when it misinterpreted a piece of training data.
Negligence law is poorly equipped to handle continuous temporal breaches stretching across the AI's life cycle. It forces litigators to identify a single proximate cause, which may not even exist.
But the source material suggested that the Canadian legal tradition might handle this more easily than the U.S. approach. Why is that?
Well, Canadian courts, particularly the Supreme Court in cases like Mustafa v. Culligan, have historically shown a lot of flexibility in adapting the standard of care to modern realities and emerging technologies.
So they're less rigid.
Exactly. This relative flexibility means Canadian courts might be better positioned to develop specific AI-tailored negligence standards, like a continuous monitoring duty, without the rigid constraints you sometimes find in the highly compartmentalized U.S. negligence categories.
Now we get to products liability, strict liability for defects. Is an AI system even a product?
That is the product question, and it's a huge fight. Products liability traditionally imposes strict liability. That's liability without fault for dangerous defects in manufactured goods.
And the law focuses on tangible property.
It does. The restatement of torts usually focuses on tangible property. And while software embedded in a car or a medical device is usually considered part of that tangible product, standalone, adaptive software is still in a gray area. Is the code a product or is it a service?
If you buy a physical toaster, it's a product. If you license a piece of software, is that the same thing?
In the U.S., many courts have hesitated to treat standalone software as a product. They classify it as a service instead. And this distinction matters enormously
Why?
because services are generally subject only to negligence claims, which requires proofs of fault. Products, on the other hand, are subject to strict liability, which only requires proof of a defect and harm.
And then we layer on the mutability challenge.
Absolutely. Products liability assumes stability. If I sell you a non-defective bicycle, it remains non-defective. An agentic system, however, learns and changes after deployment. The system sold on Monday might have developed a dangerous defect by Friday through emergent learning.
Oh.
This mutability defies the very assumptions of product stability that tort law relies upon.
So it's like selling someone a self-assembling machine, and 6 months later it decides to repurpose itself in a way that causes an accident. The original warranty and assessment of defectiveness they're irrelevant.
The legal assessment has to be continuous. And how does the rest of the world handle this instability? Well, the EU has taken a very decisive and expansive approach.
What have they done?
Their amended Product Liability Directive explicitly addresses software and related services, including updates and data provision, bringing them firmly under the umbrella of strict liability.
That's huge.
It is. And it contrasts sharply with the cautious, category-bound U.S. stance. It signals a global recognition that the core value, and therefore the core risk of the product, is its evolving code.
Moving on to causation, this is where the black box hits the wall hardest.
Causation is the most formidable evidentiary hurdle in tort law. You have to prove that the AI's specific action or decision caused the harm, not just that it correlated with it.
Right.
And the inherent opacity of deep neural networks, the black box, makes it almost impossible to fully explain why decisions were made, thus undermining traditional causation analysis.
If the AI made a complex decision involving millions of data points, and the human experts can only offer a high-level summary of the process, how can the plaintiff ever meet their burden of proof?
They often can't. And this forces courts to look for legal workarounds that were developed for situations where evidence is scarce. One is the doctrine of res ipsa loquitur.
Can you clarify that Latin phrase for us?
Res ipsa loquitur literally means the thing speaks for itself. It's a doctrine that allows a court to infer negligence without specific proof of the negligent act.
And when does it apply?
It applies when 3 conditions are met. The event wouldn't ordinarily happen without negligence. The device causing the injury was under the exclusive control of the defendant, and the plaintiff wasn't at fault.
So how might that apply to a self-driving car accident?
Well, if an autonomous vehicle, under the exclusive control of the manufacturer's system, drives straight off a clearly marked road on a clear day, a court might infer causation. They would apply res ipsa loquitur.
So the court would be saying,
this type of accident rarely, if ever, happens without some form of negligence. And since the machine was in control, we shift the burden onto the defendant, the manufacturer or the deployer, to prove the AI wasn't at fault. It's a powerful tool to mitigate the black box problem.
we might also see collective liability mentioned.
Yes, collective liability doctrines, similar to market share liability in pharmaceutical cases, might be adapted. If multiple companies deploy similar flawed AI architectures that fail systemically, say, all facial recognition systems fail to detect certain skin tones, courts might consider holding the entire sector collectively liable for the risks they introduce to society.
And again, the source material noted Canada's causation framework might be more resilient here.
That's right. The Canadian but-for test for causation, as articulated in Clemens v. Clements, it offers flexible application in complex scenarios. It allows for common-sense inferences when strict scientific proof is impossible. It's just better equipped to handle the ambiguity inherent in AI causation compared to the often more rigid American framework.
What about strict liability for abnormally dangerous activities? As AI takes over safety-critical functions, is it possible courts could start categorizing certain AI deployments this way?
That doctrine is typically reserved for extreme activities like hazardous waste disposal or blasting.
Right.
However, as AI takes over safety-critical functions, managing nuclear power plants, controlling surgical robots, running energy grids, commentators argue that strict liability, regardless of fault, should apply
Because of the potential for catastrophe.
because of the system's potential for catastrophic failure, their opacity, and their unpredictable behavior.
That would impose massive risk internalization on the deployer. They would be forced to take a huge financial hit for any error, which naturally encourages greater safety investment.
It forces those who profit from the deployment of high-risk agentic AI to bear the full cost of failure. And while this might stifle innovation in some high-risk fields, it maximizes public protection where the potential for irreversible harm is greatest.
And all this complexity just crashes into the insurance industry. If risk is unpredictable, how do you price coverage?
That's the unknown unknown problem. Traditional insurance relies on historical loss data to calculate risk probability. Agentic AI, particularly when its behavior is emergent, lacks this history. It makes accurate actuarial risk pricing nearly impossible.
Which is why some systems are uninsurable.
Exactly.
So what are the emerging solutions to this insurance gap?
Well, solutions being explored include mandatory AI liability insurance, mirroring the UK's Automated and Electric Vehicles Act of 2018, which mandates insurance for autonomous vehicles.
Or
The creation of dedicated AI-specific risk pools or compensation funds, similar to what we have in place for major disasters or specific medical liability crises. The goal is to distribute the unavoidable, unquantifiable risk of emergent technology across the industry or even society.
So we need new liability rules, but they need to be guided by sound policy. What principles should guide us toward a more coherent liability framework?
Two guiding principles stand out, pulling directly from the source material analysis. First, liability should align with control and benefit.
Meaning?
Those who profit most from AI deployment, the developers and commercial deployers, should bear the associated risks. Second, we have to institute strict transparency requirements. Developers must have statutory obligations to preserve and disclose relevant data about system behavior, the sensor logs, the network activations, to support liability determinations, and finally pierce the veil of the black box.
That transition from product to agent and from fault to emergent learning is profoundly challenging the legal playbook. Now let's shift gears and look at how governments globally are trying to manage this risk through regulation rather than waiting for courts to clean up the mess afterward.
And we see three major philosophical approaches globally: the permissive, sectoral approach of the US, the precautionary, prescriptive approach of the EU, and the horizontal, risk-based approach emerging in Canada. Each has specific implications for agentic AI.
Let's start with the United States. It sounds like they are relying on existing agencies to stretch their jurisdiction, resulting in a patchwork.
Precisely. The U.S. regulatory landscape is fragmented. It's characterized by a lack of a single comprehensive federal law. So we see existing agencies asserting jurisdiction by interpreting AI systems as falling under their existing mandates.
Like the FDI for medical AI.
The FDA for medical AI, the FAA for autonomous aircraft, and critically, the FTC leveraging its authority over unfair and deceptive practices.
How does the FTC tackle agentic systems?
The FTC is focusing on algorithmic deception and bias. If an agentic system is designed to mislead consumers, or if its emergent behavior results in discriminatory outcomes, say denying warranties based on biased algorithmic risk scoring, the FTC can step in under existing consumer protection laws. The CFPB does the same for algorithmic credit decisions, using fair lending laws as their basis.
What's the primary benefit and drawback of that fragmented approach?
The pro is that you get tailored, sector-specific responses. Autonomous vehicles require different oversight than diagnostic systems, right?
Sure.
But the massive con is compliance complexity for technologies that cut across sectors, and a general lack of baseline requirements for general-purpose AI. If an agent operates in finance and employment and healthcare, it has to navigate three different sets of rules.
The recent Executive Order 14110 seems like the federal government trying to unify things a bit, but without new legislation.
It is the most significant federal administrative action. It focuses heavily on powerful models, requiring safety testing, mandatory red teaming.
That's stress testing for vulnerabilities.
Right, and requirements for watermarking AI-generated content. For agentic AI specifically, it pushes agencies to develop guidelines that ensure safety and protect civil rights. It's essentially using the power of the executive branch to create safety guardrails where Congress has been slow to act.
Moving north, Canada's approach, the proposed Artificial Intelligence and Data Act, or AIDA, sounds much more unified and preventative.
AIDA is a fascinating middle path. It's aiming for responsible innovation. It's a comprehensive national framework, but it is horizontal, meaning it applies general rules across all sectors, specifically targeting high-impact systems.
And how are these high-impact systems defined?
They're defined as systems whose failure or misuse could result in significant harm to health, safety, economic well-being, or human rights. Think employment screening tools, critical infrastructure management, or law enforcement systems. This scope is crucial because agentic AI, by its nature, is designed for high-impact strategic roles.
So what does ADA require of developers deploying these high-impact agentic systems?
It imposes robust lifecycle obligations. Developers have to conduct risk assessments before deployment, implement mitigation measures, provide transparency to users, and, critically for adaptive AI, engage in ongoing monitoring and incident reporting.
That ongoing monitoring is key.
It's essential. The framework recognizes that adaptive systems change post-deployment, so continuous monitoring is essential for sustained compliance.
But I remember you flagging a potential challenge with this Canadian model, relying on the developer's own assessment.
That's the loophole concern. ADA relies significantly on the developer's self-assessment of the system's impact level. For highly emergent or general-purpose AI, where new, potentially high-impact capabilities develop unexpectedly weeks after deployment, this self-assessment model might create gaps in oversight until the damage is already done. It relies heavily on good faith.
Now, across the Atlantic, the EU's AI Act is the global benchmark for regulation. They're leaning heavily toward precaution, establishing the most prescriptive rules.
Absolutely. The EU AI Act, adopted in 2024, is the most comprehensive globally. It establishes a rigid, risk-based pyramid.
What does that pyramid look like?
At the top are prohibited AI systems like social scoring. Below that is high-risk AI in critical infrastructure, employment, finance. Then limited risk like transparency requirements for chatbots. And finally, minimal risk, which has almost no rules.
How does that specific risk pyramid impact agentic AI?
Agentic systems are overwhelmingly designated as high risk if they operate in critical sectors. These systems face stringent rules on data governance, documentation, accuracy, and human oversight. And since agentic systems are inherently adaptive, meeting these stringent compliance requirements is a massive engineering and legal challenge.
So they have to keep records.
It forces companies to maintain extensive verifiable records of how and why the system learned a certain behavior.
So the Act creates massive documentation requirements to mitigate the black box problem.
Exactly. Furthermore, the Act has provisions for general-purpose AI models, establishing upstream transparency requirements for the foundation models upon which many agentic systems are built. This ensures that even if you didn't train the core model, you have certain guarantees about its safety and testing history.
And the EU Act has that infamous global reach known as extraterritoriality.
Correct. The Act affects any AI system that impacts EU residents regardless of where the developer is located, giving it global influence. This forces developers worldwide to adopt EU standards if they want to operate in that immense market.
And there's more.
Complementing this is the proposed EU AI Liability Directive, which aims to help victims by creating presumptions of causality in high-risk scenarios, effectively shifting the evidentiary burden away from the injured party, recognizing the difficulty of piercing the black box.
So, despite all these global efforts, US, Canada, EU, what are the gaps? What are the regulatory challenges specific to agentic AI that no jurisdiction has fully solved yet?
4 major gaps persist. First, adaptive compliance. How do you verify compliance for systems that continuously learn and change post-deployment? You need a continuous monitoring regime, not a one-time audit, and that is a major logistical challenge for regulators.
Which means the rules are always playing catch-up to the evolving system.
Exactly. Second, emergent behavior. Static regulations struggle to capture capabilities or tendencies that develop unexpectedly, especially in general-purpose AI. If an AI suddenly develops unforeseen risk-taking behavior in a simulated environment, who is responsible for catching and reporting that if the original risk assessment was perfect? Multi-agent systems. Current rules focus almost exclusively on individual systems. What happens when multiple autonomous agents from different developers collaborate or compete, say, in a financial market, or on the energy grid, creating systemic risks that no single developer intended? We lack frameworks for this collective behavior and systemic failure.
And finally,
And fourth, human-AI teaming. When humans and AI share decision-making, the AI advises, the human approves. We need clear rules for responsibility allocation. This requires something like an updated pilot and command model for different industries, defining when the human must override the AI and when the human is allowed to trust the AI completely.
this deep dive has shown that the legal system's fundamental expectation, human control over every action, is being shattered by machine autonomy. The future of governance must pivot entirely.
The future has to pivot from regulating direct, granular control to regulating autonomy itself. We need to move toward distributed control or meta-control, setting the boundaries and parameters within which the autonomy is allowed to operate, rather than attempting to micromanage every decision. The law has to trust the AI within those guardrails, but heavily regulate the guardrails themselves.
Despite the staggering technical and legal complexity we've discussed, the analysis consistently returns to human values. What are the key values the legal frameworks must preserve above all else?
We have to preserve access to justice. AI should never function as a liability shield, making it impossible for injured parties to seek compensation. We have to ensure equity, actively combating the bias amplification that often results from AI trained on flawed data.
And human dignity.
And we must preserve human dignity by ensuring meaningful human involvement in consequential decisions, particularly in life-altering areas like healthcare, criminal justice, and fundamental rights.
This requires governance that is as adaptive as the technology it's supposed to be monitoring. What mechanisms allow the law to keep pace without just reacting after a disaster?
We need governance systems that are themselves adaptable. One key mechanism is the use of regulatory sandboxes, controlled environments that allow for developers and regulators to experiment together, generating data about risks before a large-scale deployment.
And what else?
Another is adaptive legislation itself. This means laws that include regular review mechanisms, sunset provisions, and statutory authority to update risk lists quickly, similar to what Canada's AIDA proposes for its high-impact systems list.
So if the technology is constantly learning and changing, the rules need to be structured to constantly learn and change too. We are regulating a moving target.
Precisely. The most profound challenge posed by agentic AI is not merely changing laws. It's requiring a renewed understanding of the relationship between human agency and artificial responsibility. We have to ask ourselves, as we delegate our fundamental capacity to act independently to intelligent machines, are we maintaining sufficient societal control over the future we are collectively building?
And that's the question.
That's the question that will define the next century of law and governance.
A truly profound thought to end on. The legal system must either adapt and anticipate or risk becoming an obsolete relic. Thank you for guiding us through this incredibly complex landscape.
My pleasure.
That was the deep dive, unpacking the legal paradoxes of agentic AI. We'll be back soon with more insights from the cutting edge of information.